I wanted to tell you just a tiny bit about how this event came about. As many of you know, the Los Angeles County Bar sponsored the Judge Robert Weil Memorial Lecture for many years. And with the sort of new aura that's in the Los Angeles County Bar, they decided to make some changes, and one of the changes was the sunsetting of the Center for Civic Mediation. So two of the stalwarts who had created the Weil Lecture and who are close friends of Western Justice Center, and that's Rich Chernick over here and Max Factor, sort of negotiated or engineered the transfer of this lecture to the Western Justice Center, which I was particularly happy about because I considered that Bob Weil was one of my mentors when I was a brand new judge on the Superior Court. So I'm just very happy to have taken this over. In doing this, we got some fabulous sponsors, and you'll see on the special thanks that I put out there, our gold sponsors, Rich and Max. We also have David and Annette Weil, that's Judge Weil's son, the Rudder Group and Jeff Kribis. As silver sponsors, Judith West, ARC, Gerard and Keys, Munger, Tolles and Olson, Jams, Daily Journal, Latham Watkins, and the California Judges Association. As bronze sponsors, William Fitzgerald, who I see right here, in the stunning red tie. Deborah Sachs, who I know is here someplace, there she is, and Steve Paul. Brown, George, and Ross, and our co-chair, Pat Kelly. Extra thanks, and I realized after I had these printed that I forgot to specifically thank on here our co-chairs, which is Pat Kelly and John Pastor, who's sitting in the back there, who prepared our introductory materials and our case list for us. I wanted to acknowledge Executive Presentations, which has been a great friend of, they do the graphics for trials. They're a great friend of Western Justice Center, and they did the boards for us. So we particularly appreciate that. Additional special thanks to Dave, where are you? Dave Schindler, who is our host here at Latham and Watkins, both for the location and that fabulous food. And to his staff, Faye, his secretary, who is just really terrific, and the other folks who've been helping us out. And then, of course, to our panel, I also, and I'm going to introduce Howard Miller in a moment, and he's going to introduce the members of the panel. I will tell you two things. We are videotaping this, and we have a relationship with an organization that has a relationship with West Publications and their digital, whatever, their online things, so that this will be a CLE program that is available to people who somehow get their MCLE credits online, the people younger than me, actually. And so that's why it's being videotaped, so I just wanted to mention that to you. Those of you who signed up for MCLE credit, you will get your certificates by email, your certificate of attendance by email from the folks who have coordinated that for it. I am really interested in this program, and I will tell you, as I interview Howard, and as I said, he will introduce Howard, and he will introduce the other members of the panel, I will tell you that if this program is half as interesting as the emails that were flying back and forth among the members of the panel, it's going to be a terrific evening. The one other thing that I would be remiss in if I forgot to mention is that this is one of the things that Western Justice Center does. We also do, our main focus at this point is also conflict resolution and anti-bias programs for schools and communities. And you saw, I put on with each of your sets of materials, our little program brochure so that you can see what other kinds of things that we do for the community and for the schools. And of course, the money that we got from the sponsorships for this, and those of you who actually paid individually to come, because of the generosity of our sponsors, all of the money that we've received will go to support our programs, and we would love to have you take a look on our website, see our other programs, and see if there are some things that you would like to either become involved with or support in some other way. So with that, I'm going to introduce Howard Miller, who is a partner at Girardi & Keys, former president of the State Bar, and my corporations teacher in law school.
Thank you, Judy. Thank you very much. It's a real honor to be here. Again, thanks to Latham for hosting this. It's much, much appreciated. This, of course, it's named in honor of Judge Robert Weil. Those of us who knew him and were his friends would know how much he would have enjoyed being here tonight, how great a lawyer and how great a judge he was. And this is a fitting tribute to his career. We really have an outstanding panel to discuss this program tonight. Their full bios are in your materials, I think, but let me briefly introduce them. Theani Evangelos is a partner at Gibson, Dunn & Crutcher. She is central to their litigation department. She clerked for Judge Alice Kaczynski after graduating first in her class in NYU Law School, and then for Judge Sandra Day O'Connor. And if you want to read one of the most charming things about clerkship, she has a little piece in one of the local bar magazines about how when she applied to Justice O'Connor had her fly to Phoenix for the interview. Justice O'Connor picked her up at the airport. And it's one of the more charming notes that you'll read about being a clerk. She is with us. She's central, as I said, to the Gibson Dunn Litigation Department, which is involved in so many of these cases. Next to Theani is Cliff Pilevsky, well known to all of us. Cliff has been involved in all of these leading labor cases. I think I can introduce Cliff as one of the two leading plaintiffs' employment lawyers in California. The reason I always say that when I introduce a plaintiff's lawyer is so none of my friends will be offended. But Cliff is a legend in the area. He's been involved in all these cases, so many of the cases we'll talk about. He has been counsel, and he is right at the forefront and has been for decades of the battle at plaintiff's employment lawyer. Next to Cliff is Judge William Heiberger, sits in Central Civil West, has been on the court now for
almost 19 years.
Almost 19 years, partner at Gibson Dunn before he went on the court. He sits in Central Civil West and deals with all these complex issues on a daily basis in his courtroom, and also has written, and there's a link to it, the article that he wrote for the Los Angeles Lawyer is one of the best summaries of the of the cases up to a year ago, pre-Kindred, pre-McGill cases in terms of arbitration. Next to Judge Heiberger is Rex Heinke, a partner at Aiken Gump, co-head of their appellate practice. Nationally, Rex has argued over 140 appeals, he told me, and he also has been at the center. The cases we will discuss in which cert has been granted in the U.S. Supreme Court, 3 labor cases. The key case is the Ernst & Young case that has come out of the Ninth Circuit. Rex has been counsel for Ernst & Young. He was one of the authors of the cert petition that was granted and deeply involved in how that litigation will proceed. We're especially pleased he's here because the merits briefs are due on Friday, so that he would take time out and be with us. And after introducing the panel, I can't help but notice as well how pleased and honored we are. Justice Carlos Moreno is with us, back from his ambassadorship to Belize. It's especially appropriate that he's here tonight. He was on the Supreme Court of California from 2001 to 2011 and was the author in pre-Concepcion days, author of the 4-person majority decision in 2 of the key cases that Concepcion has affected, the Gentry case on labor and the Discover Bank case. And of course, the Discover Bank case, the opinion of which he wrote expressly in the Supreme Court's Concepcion opinion, says the Discover Bank opinion is preempted. So we're not going to let Justice Moreno leave the room without getting some comment.
The panelists are more kind to me than the Supreme Court. You were right.
This is a very sophisticated audience. I think, amazingly, I think I know almost everyone in the room, and despite the distinction of the panel.
I'm having trouble hearing you in the back, so you
Okay.
gotta get the mic.
Okay.
There's other things that you have just for the taping,
Yeah.
so you need the mic.
Thank you, Judy. So despite the distinction of the panel, from what I know of people in this room, we could ask you randomly to be on the panel and have a similar level of expertise. I think everyone knows what we're here to discuss tonight. Three things frame the issue we're going to be talking about. The first is the Supremacy Clause of the U.S. Constitution, Article 6, Section 2, that the Constitution and laws of the United States shall be supreme, and the judges in all states are obligated to obey them, anything to the contrary notwithstanding in the state laws. So all this goes back to the Supremacy Clause from the Constitution. Secondly, to a federal statute, to the Federal Arbitration Act, which in 1925 made contracts for arbitration enforceable, irrevocable, and valid, and established that law as a substantive basis for enforcing contract law. And the third is AT&T versus Concepcion, which came down in April of 2011, I think less than 2 months after Justice Moreno left the court. And AT&T versus Concepcion dealt with the issue under the Federal Arbitration Act, whether if an arbitration clause provided, the language of the clause said, there shall only be a right to individual arbitration and not to act in any representative capacity, class or otherwise, by the person who signed the arbitration agreement. That is widely known as the class action waiver, and it is that ruling of Concepcion that frames everything we are going to be discussing tonight in terms of how it affected the California law, what the post-dispute about it has been, and what it's likely to do going forward. What we're going to do, divide this 2-hour period into really 3 segments. In the first 45 minutes, we're going to discuss consumer arbitration and focus on that for 45 minutes and just talk about consumer arbitration. In the second 45 minutes, we're going to turn to employment arbitration, especially a discussion of the cases now in the U.S. Supreme Court that, according to schedule, will be fully briefed in August, argued in the October term, and will be decisive because, as you see, the issue is framed to make it decisive. Then we've left 30 minutes at the end for a general discussion of predictions and discussion about the values involved and where we go from here. Though we've divided it that way and given people assignments for presentations, the purpose of this is to be an interactive session. We've left time for questions, and we encourage anyone at any point in the presentation, whoever is speaking, if you have a question about what's being said, if you have other questions, please ask it. We'll make sure that everything is covered, but we want to make sure that you're comfortable participating in what we hope is an interactive couple of hours. But we'll begin with the consumer arbitration and California law, beginning with Theani. Theani?
Thank you, Howard, and thank you. It's a pleasure to be here with all of you tonight. As Howard mentioned, and as all of you know, Concepcion really was a watershed decision in this area, and it overruled California's Discover Bank rule, but one might not know that from some subsequent cases where California courts have been pretty reluctant to embrace Concepcion and to really run with it the way the Supreme Court seems to be telling them to. So after Concepcion, many companies started including consumer arbitration agreements in their contracts, so they've become much more prevalent. But the legal issues have only increased. And one case where I think the U.S. Supreme Court recently told California courts that it meant what it said in Concepcion is the DIRECTV case. And that case, as you may know, went to the Supreme Court from a decision of the California Court of Appeal in Imburgia versus DIRECTV, and that was in 2014. And it was interesting because the agreement said that if, quote, if the law of your state would find this agreement to dispense with class arbitration procedures unenforceable, then this entire section is unenforceable. So notwithstanding Concepcion, the court held that California law would not enforce the class waiver, and therefore the entire agreement was unenforceable. Of course, that was under the Discover Bank rule, which had been overruled. So the Supreme Court granted review in that case, and also notable in a decision by Justice Breyer, reversed. And again, I'll just note that the decision was very, very forceful, and it, among the I think notable statements, it said that the Supremacy Clause forbids state courts to dissociate themselves from federal law, and judges of every state must follow it. So it was a pretty harsh rebuke, I think. It is also important that now there is not just a 5-4 majority in the Supreme Court, and now with Justice Gorsuch, it's that hasn't changed. But to see that decision from Justice Breyer is significant. And then, it hasn't all been resistance to arbitration. In another case in 2015, the California Supreme Court followed Concepcion and Sanchez versus Valencia holding, and there it held that the FAA preempted a provision of the California CLRA, which barred class waivers, and the court followed the decision, and there was a dissent from Justice Chin, but it was on relatively narrow grounds about unconscionability and what constitutes unconscionability. But Sanchez was a pretty strong decision about the enforceability of class action waivers under California law after Discover Bank, and also the opinion noted that that arbitration agreements did not have to be in bold, flashing red lights in the agreement, didn't have to be called out in a way that disfavored them, and so I think that's also a very important ruling, because so much of the discussion about consumer arbitration agreements has been about whether they're contracts of adhesion and whether they are substantively unconscionable, and so the decision provides guidance on those issues. And I'm going to lead up to the recent McGill decision, but another case before we get there that I would like to mention is a decision from last summer, from last July, from the California Supreme Court in Sandquist versus Lebo Automotive. And that addressed the question of who decides, and it's about whether courts or arbitrators should decide whether class arbitration is available. So not whether, and whether the parties agreed to class procedures in arbitration. And the California Supreme Court's decision departs from the decisions of several federal courts of appeal. And so there is a split on this issue now, and it's an important one. And although there was no cert petition filed in that case, I do think that the issue is likely to go up to the Supreme Court. It's an open question, and the California Supreme Court held that that under the FAA, if it is uncertain whether the issue is one for the courts or the arbitrator, we are well advised to allocate it to the arbitrator. And of course, many have discussed the problems with that, and that it should be courts who are deciding that, whether it's a threshold issue of arbitrability is an open question, and the Supreme Court has said as much in a couple of decisions now, including in Oxford Health Plans. So I do think that that issue is one that's likely to go up to the Supreme Court. And that brings us to McGill versus Citibank, which was decided just a couple months ago. And there, the California Supreme Court held that a provision waiving the right to seek public injunctive relief is unenforceable under state law, and it rejected the argument that the FAA preempts that rule. So in McGill, that case involved an unfair competition and false advertising action against Citibank, and the plaintiff sought a number of remedies, damages, restitution, and injunctive relief. And the parties agreed on the terms of the arbitration agreement and what it prohibited. And the court held that that waiver, because it confers a benefit on the public, because public injunctive relief confers a benefit on the public, is contrary to California public policy and unenforceable. And they said that the FAA doesn't preempt that waiver because it is neutral as to whether the waiver is in court or in arbitration. It doesn't matter. It's not waivable. And the court held that it was a substantive right and not a procedural right to seek injunctive relief, and that it was a remedy under California consumer protection statutes. And I think that that's an important part of the decision. Much of the decision is about whether the UCL and California consumer protection statutes allow an individual to seek public injunctive relief on behalf of other absent individuals who are not part of the case when the class action procedure is not being invoked, and whether, despite Proposition 64, that's permissible under California law. And the court held that it is, and that is a substantive remedy under California law, and that it's an arbitration neutral rule that they believed they were adopting, and that it would be applicable to any contract, not just to arbitration agreements. So the interesting issue there is not only whether that rule can be considered substantive as opposed to procedural, but also whether that rule undermines the fundamental attributes of arbitration. Because, of course, if you recall, Discover Bank was also a neutral rule, and it held that class waivers were unenforceable, not just in arbitration agreements, but more broadly. And so this rule is similar in that regard. And when an individual is seeking public injunctive relief on behalf of absent persons, does that so change the efficient bilateral nature of arbitration that the Supreme Court emphasized in Concepcion, and that led it to overrule the Discover Bank rule? So some of the same arguments.
Leave the room.
I will.
Yeah.
Let me turn this down.
Guess it's not my courtroom. Okay.
So and I'll, and I know you want to hear from the rest of the panel on these issues, and I've been talking for some time now, but one issue that was raised in McGill but not decided is the continuing viability of the Broughton-Cruz rule in California. That is the rule that predates Concepcion and provides that agreements to arbitrate claims for public injunctive relief under the CLRA and the UCL and false advertising law are unenforceable. So under that rule, you can't arbitrate those claims. And it would seem to me that that's clearly preempted by the FAA after Concepcion and the decision in DIRECTV, but it hasn't squarely been overruled. That issue didn't come up because Citibank and the petitioner agreed that the provision in that case precluded the petitioner from seeking public injunctive relief in any forum. So it wasn't merely an agreement to arbitrate those claims for injunctive relief, but merely to bar them more broadly. So that issue wasn't decided, and it remains out there, but I'd be interested if anyone on the panel thinks that rule is still viable.
A couple of comments and then a question. Just to add to the discussion of the DIRECTV case, not only was the opinion by Justice Breyer, but it was signed by Justice Kagan as well, basically both taking the position that even though they dissented in Concepcion, they now recognized the rule. There were also a couple of throwaway lines in Justice Scalia's opinion in Concepcion that was very interesting. At one point, he talks about the argument that contracts of adhesion are procedurally unconscionable. Then he has a throwaway sentence that says, today there are hardly any contracts that aren't contracts of adhesion, as though using to flip it on its head and say, well, they're all contracts of adhesion, so you can't call it unconscionable. There's also very interesting language where he seems to suggest that the unconscionability analysis under general California contract law may have to yield to the purposes of the Federal Arbitration Act, even though there may be circumstances where the California law would find that a contract was unenforceable. Cliff, you've got a, I think, somewhat different view of this than Theani. What's going to happen in McGill and why? What?
I have to talk about McGill first. Well, McGill was written by Justice Chin. Keep in mind, after Armendariz, I think Justice Chin dissented in almost every one of the cases I was involved in, and he saw preemption everywhere. So the fact that Justice Chin wrote a unanimous opinion, essentially, in McGill should tell you something. That the Supreme Court has engaged in a series of fictions. They kept saying things that they did not mean, such as arbitration is just a forum with no impact on substantive rights. That's never been the case because you can't appeal an incorrect ruling. But in every one of their cases, from Mitsubishi and Shearson right up to the end, they say you don't lose substantive rights. McGill was a straight-ahead deprivation of substantive rights. It said you cannot prevent this substantive right, the public injunction, in every forum. That's the key here, is that what the U.S. Supreme Court has done has probably aided this arbitration business, but has undermined and is on the verge of destroying the institution of arbitration, the acceptability of arbitration. And I think I would like to spend some time later on taking advantage of the sophistication of this audience to actually have a more soulful discussion of where we are. I mean, we can sit here and take a look at Concepcion and say, yes, it was a 5-4 decision and it's the rule. But I think we need to go a bit deeper than that to do justice, because I think everybody in this room is a strong supporter of ADR and the institutions of arbitration and mediation. And I think that by focusing on this case and that case, we're losing sight of the big picture. The part of the heading of this was the tension between the California Supreme Court and the United States Supreme Court. It's not just the California Supreme Court. It's the New Jersey Supreme Court, it's the Oklahoma Supreme Court, it's the West Virginia Supreme Court, it's the Alabama Supreme Court. What's happening out in the courts is really a form of, I'll call it, judicial civil disobedience. That the U.S. Supreme Court went off the tracks in Concepcion. They went too far. It was an extraordinarily dishonest opinion that reversed years of precedent regarding unconscionability not being impacted by the FAA. The thrust of the opinion was that arbitration is not, class actions are not appropriate for arbitration, which is something I actually agree with. And that you can't force someone to have a class arbitration against their will, which I agree with. But that's not what the Ninth Circuit did. The Ninth Circuit said it belongs in court. Justice Scalia went off the tracks, and I think that what we're seeing now is that judges, sitting judges who actually understand the difference between arbitration and the courts, academics, and fair-minded people recognize that it's not just the FAA. We can't start the analysis with the FAA. That is a statute. The analysis starts with the Constitution, and not just the Supremacy Clause. The First Amendment right of petition, the Fifth Amendment right of due process, the Seventh Amendment right of trial by jury. Those are constitutional rights. They are preeminent. The FAA does not have the authority to reduce the standard required for the waiver of constitutional rights, period. We have briefed and tried to argue, not only to the U.S. Supreme Court, but the California Supreme Court, that there is a constitutional impact in an arbitration agreement. It can't be, and it's very funny, when we argued the Circuit City case to the U.S. Supreme Court, we had to go deep into the legislative history of the FAA. And at the time, the courts were hostile to arbitration, and they would not enforce pre-dispute agreements. And the legislative history actually says that the purpose of the FAA was to allow courts to enforce arbitration agreements the way they would other contracts. Somehow that's been turned upside down so that it requires courts to enforce arbitration agreements as they would other contracts. But arbitration agreements are not like other contracts. Other contracts can involve commercial terms. Arbitration involves the waiver of constitutional rights. In every single context other than arbitration, the waiver of constitutional rights has to be knowing and voluntary. The public policy that allegedly favors arbitration can't exist because it's contrary to the Seventh Amendment. It's contrary to the First Amendment. And for some reason, the U.S. Supreme Court will not ever address the constitutional implications of what they've done. The public policy that they say favors arbitration can only mean it favors encouraging parties to voluntarily select arbitration. One of the biggest flaws in their reasoning is their failure to distinguish between real contracts and negotiated contracts and adhesion contracts. You can take almost all of their cases, even Concepcion, and if you have two sophisticated parties who want to flip a coin, you can flip a coin. But you can't use that analysis when you're talking about consumers or people who don't have bargaining power, where it's not a real contract. The waiver of constitutional rights cannot be accomplished in that way. The only check and balance that was ever contemplated for arbitration to keep it fair was the consent of the parties. That if they don't think it's fair, they don't go. If they don't get the discovery they need, they don't go. If they don't get the arbitrator they want, they don't go. When you eliminate consent, you are eliminating the only check and balance, and you're turning an adversary system over to one party and asking them to design the rules. By design, it can't possibly work. And it's a flaw because it's undermining the integrity and the perception of the process. It's not just the California courts. The Democratic platform literally opposed mandatory arbitration. Up until recently, almost every government agency charged with enforcing our labor and consumer laws opposed it. Congress passed legislation opposed. If you want to talk about what is the public policy presently, we know what it was in 1925, and when the Supreme Court decided to rewrite the factual history of what Congress intended about employment cases. They have opened the door to what is really, and we need to be candid with this, class action prohibitions have changed everything. Concepcion was a watershed. Aside from the intellectual aspect of it, it basically allowed companies to ban class actions and to suppress claims and to opt out of the law. That's what made it a watershed. Prior to the ability to ban class actions, many companies weren't all that interested in arbitration. They didn't want to pay for it. And the pluses didn't necessarily outweigh the minuses. Allowing companies to literally opt out of the law and to suggest that the Federal Arbitration Act requires courts to enforce anything that a company writes into an arbitration agreement does a disservice to the Constitution, to the very concept of a public courtroom, and to the laws that we say we cherish, the labor laws, the civil rights laws, the consumer protection laws. So, the law's terrible, and it's getting worse. But I think what's happening in the courts is not tension so much as a form of fidelity to the Constitution. And I don't mean to be too flip about this, but I've had enormous relationships with people in the ADR business because for many years, literally, JAMS and AAA would, ask me to be in their press releases, to be on their panels because I believe so strongly in ADR. But at some point, I went to the ABA and I said, I feel like I'm dealing with a friend with a drug problem. Where they're looking in the eye and they're just talking and and they know that what they're saying isn't really what's going on. And it was funny, SCOTUS blog did a symposium after Concepcion came out, and there were 19 people, plaintiffs, lawyers, academics, judges. Not one person tried to defend Concepcion. And what I said then is what I really think. I think that what we need is an intervention, a form of a legal intervention, because the law is so mangled.
Mr. Ryan and President Pro Tem
I think that the best.
Kentucky will do that for you in about a day.
Well, Cliff, I'm going to commit lèse-majesté and interrupt here and ask you a question. So We all implicitly or explicitly take an oath to uphold the United States Constitution.
All
You're,
of it.
you're a lower court judge. The Supreme Court has clearly ruled in a case in which you think they are absolutely incorrect under the United States Constitution, but you're still a lower court judge. What do you do? Are you obligated to follow the Supreme Court, or is there some other law that gives lower court judges the power and right to write an opinion different than the clear law set down by the Supreme Court?
Well, that's an easy question. You are legally obligated to follow Supreme Court precedent, but you can write an opinion that says it is wrong, it is unconstitutional. When you're not writing that opinion, you can go to the legislature, you can talk to the newspapers, you can participate in the public dialogue like the National Academy of Arbitrators did, like several federal judges have done, like Arthur Miller has done, like the leading academics have done. And you say, I'm obligated to follow this, but it is wrong, it is very wrong, and it is demeaning the role of the courts and the institution of arbitration. David Feller, who was a giant, who argued the trilogy of cases, who believed in arbitration more than anyone, wrote a brief to the Supreme Court that said, you may think it's unusual or odd that an organization of arbitrators who make their money from arbitration would side with the plaintiffs here. But our fidelity is to the institution, and that without consent, arbitration lacks a legal or moral justification. That's what every judge with a conscience should do, whether you have to follow their decision or not.
The best book on this, by the way, in terms of how this question should be answered, is a book by Larry Kramer, the former dean of the Stanford Law School, which is entitled The People Themselves, which is one of the most interesting and effective reinterpretations of Marbury versus Madison and the power of the courts. And it's well worth a read. It's not just my opinion. It was widely praised when it was published. The People Themselves by Larry Kramer. It's on Amazon. I do not get a commission. Rex, I assume that you agree with everything that Cliff has said?
Of course.
Well, that ends the panel.
Well, then, there we go. It seems to me what we're dealing with here is a serious public policy issue. Elections have consequences. Congress is not going to change the Federal Arbitration Act. And I believe that what the Supreme Court did in Concepcion is correct, given the existing Federal Arbitration Act. I don't see how California could, with all respect to Justice Moreno, I do not see how California can have a policy that says that class action waivers are per se unconscionable. That kills arbitrations. Now, is that good public policy? Cliff doesn't think it is. Other people think it is good public policy, and I think reasonable people can disagree about that. But in terms of the state of the law, I think the Supreme Court was right. Now, some of these other cases, McGill I find to be a very strange case, because in McGill, what happened there was, yes, they agreed to arbitration, but I don't think it's an arbitration case, because what plaintiffs had to agree to in McGill was they had to give up any right to injunctive relief. I don't understand why that is an arbitration case. That's a completely different case, because you're giving up substantive rights. And so I don't see McGill as an arbitration case, and I don't think it's controlled by Concepcion, and I don't think it's wrongly decided, because I don't understand this idea that you can force people to give up substantive rights.
Including Section 7 of the NLRA?
We're about to get to that. That's the next subject.
You want to get to that now?
Not right now. Keep
All right.
going. I'll ask Judge Heiberger about this, and then we'll get to that.
All right. So, if Congress wants to change the Federal Arbitration Act, Congress has the power to do that. The President wants to propose changes to that, he has the power to do that. But I think under the current Federal Arbitration Act, the Supreme Court was right in Concepcion. You cannot have a per se rule that wipes out class action waivers. On the other hand, some cases like McGill, while some people jump up and down and say, you know, this somehow violates the Federal Arbitration Act, I don't understand it. It's not really an arbitration case. I doubt the Supreme Court, U.S. Supreme Court, is going to have a whole lot of interest in it because it's not really a federal arbitration case. It's a case about giving up substantive rights, which doesn't have anything to do, per se, with the Federal Arbitration Act.
Well, we're about to find out. The decision in McGill came down in April. The 90 days, I think, are up to file a cert petition sometime in July, so we'll soon know whether the cert petition. Judge Heiberger, how do you look at cases like McGill? And most interestingly, as a judge who often has to deal with conflicting signals from different levels of appellate courts, how do you deal with this kind of issue where there seems to be real differences between the U.S. Supreme Court and the California Supreme Court?
Well, there's so much worth saying on the topic. I'll jump around, but I'll try to be short. Rex and I actually were first-year law students at Columbia studying legal method 45 years ago in August. And they got some professor, Professor Murphy, who apparently had to work 8 days a year as long as he showed up sober. And he taught us legal method. And then I guess I left him alone for the other 50 weeks of the year. But there was like Holy Trinity Church and something about, you know, the contract labor statutes of the U.S. showing the court's tension about how to interpret a statute. If I were teaching legal method, you could just, the cases that have come down under the Federal Arbitration Act, you got to start a little bit before Concepcion, but you just take them all and you watch the tension between the West Virginia court, the Kentucky court, the California Supreme Court, Justice Moreno's decisions, and it's just fascinating because it's perfect for legal method. Having said that, first, two cases not mentioned, really worth emphasizing, include the most recent decision of the U.S. Supreme Court in Kindred Health. 7-1, Clarence Thomas keeps saying the Federal Arbitration Act doesn't apply in my court, but that's a voice of one. That's also fascinating because the smart defense lawyers, like Rex and Dan, only take district court and court of appeal cases to the U.S. Supreme Court to challenge these things. They don't take a state court case because you'd lose Clarence Thomas's vote back when it mattered. Because if you put a state court, now Imburgia was a state court case. Somehow that one went down, but Kindred, 7-1, if memory serves me right. Gorsuch didn't vote, Thomas said didn't apply. But the Supreme Court's got a brand, dare I say it, the U.S. Supreme Court, and that is people actually follow their decisions, and they don't want to take 1,000 cases a year to do what is called a grant vacate remand, which is their idea of failing your term paper and sending it back. They could, but they don't want to. They do it on occasion, and they use it as a way to slap around the lower courts. Carlos has had the experience. But basically, when they issue a decision with a logic to it, they want the lower courts to sort of understand the logic and apply it without having to actually have their homework scored, because that's a lot of trouble to do this kind of fail and return your paperwork with a grant vacate and remand. But as noted by Howard, we now are getting Breyer and Kagan coming around, and even Sotomayor in the Kindred case, and saying, you know, we lost 5-4, but the brand matters more than my vote when I lost. Because if the lower state court appellate cases or courts decide they basically can get away with what they want to do and not be noticed, chaos. And the U.S. Supreme Court cannot afford that. They have to scare the lower appellate courts in their published cases to follow the logic of their precedent. And that's what they're telling us in Kindred and in Imburgia. The other case that wasn't mentioned, but certainly notable, is Italian Colors, American Express versus Italian Colors Restaurant, technically, where the Supreme Court had to turn itself in knots on the question of substantive rights versus procedural rights because the cogently argued position of the yeoman merchant Italian Colors Restaurant against the rapacious credit card processor American Express was that they were being killed by the clearing charges that American Express wanted, but there were commercial reasons why they sort of couldn't resist it, but it was a violation of one or another of our various federal antitrust laws, and this shouldn't go down. But the economics of litigating an antitrust case are so brutally expensive to hire a forensic economist that if you couldn't make a class action out of it, at least according to the fact-finding of the trial court and the fact-finding of the Second Circuit, you could not effectively litigate the case if you didn't have a class action. And it was on that record that the U.S. Supreme Court had to say, oh, never mind, under Mitsubishi, if theoretically you could go like take a collection at the Franchisee Restaurant Association annual meeting and see if other people would contribute to your cost of litigating a case, then theoretically you could litigate your case so you didn't lose your substantive right, because in a world that they hypothesized, it would be possible to litigate it. So that really tells us things when the U.S. Supreme Court said that is okay, and that really speaks out. It is true that we watch our legislature every year. Even Governor Brown, not your typical red state governor, vetoed, like 24 months ago, I think it was, a bill passed by our legislature that was going to prohibit arbitration because at that time we were waiting on Imburgia and MGH government services and several cases that would challenge things. The Armendariz case came within one hair's breadth of being overruled in the last term of the Supreme Court, because there was an unpublished decision of the Ninth Circuit. I believe it's Zaborowski versus MGH Governmental Services. Had to do with an alleged independent contractor, and it in turn tested the Armendariz logic via the federal courts. And in an unpublished 2-to-1 decision of the Ninth Circuit, they had found that the clause in question was unenforceable and it would take too much blue pencil to fix it. The dissent basically quoted the contract in question, showed with its editorial highlighting the blue pencil required, and said basically it wouldn't take much blue penciling at all, but the majority had said that Armendariz, it was too much blue penciling and therefore they wouldn't enforce. Now, why does the U.S. Supreme Court bother to grant cert for an unpublished opinion of a lower court? There's nothing precedential about the unpublished opinion of the lower court. There's no problem really to fix from a casebook jurisprudence point of view. The U.S. Supreme Court took that case, though. And that case was directly nothing but a carbon copy of Armendariz via a subsequent ruling of an appellate court applying faithfully California state law, as it was, because it was a faithful application of California state law by the majority. Pardon?
No, that only dealt with the severance portion of Armendariz.
Well, but how much blue pencil? Yeah, but that was within.
What's going on, that's a class.
No, I got another point, though. Give me another minute or two, Cliff. I'm getting to a point you'll like, I think. But they took it, but then I talked to actually petitioner's counsel, and the case disappeared from the docket because once it got cert granted, the employer petitioner got a settlement offer they couldn't refuse, and so there went that guy's chance to get a quill pen arguing to the Supreme Court, and the case settled, so it disappeared from the Supreme Court docket. At its core, I think, with Concepcion in particular, but also Italian colors, what we're seeing out of the U.S. Supreme Court, at least as it was constituted until Scalia's death, but I think really it reflects a number of the judges who've cast the majority votes, is a core dislike of class actions. So really what we have going on is a billiard table shot about class actions with the billiard ball careening off the sidewall in order to get the ultimate target, because there are a number of justices on the Supreme Court who think that class actions are out of control. They haven't been able, through the Rule 23 amendment process, to do anything that would change that, which is understandable because the U.S. Supreme Court doesn't control the amendments to Rule 23. But they don't like class actions. I mean, they really, really, really don't like class actions. And if you, through the magic of class action waivers, can find a way to euthanize class actions, they will accept any therapy available because their distaste for class actions is so extreme. The one other comment I'll make before I give it back to Howard is, from a trial judge's point of view, one of the things that is most problematic is the variation of the language of the arbitration agreements presented is almost infinite. It's like every second-year associate at Jackson Lewis or Littler Mendelsohn or Gibson Dunn or whatever is out there amending last month's draft of an arbitration agreement to respond to last week's appellate decision. And they are all over the map in terms of the language. Give me an American Arbitration Association form agreement that's been out there for 20 years and tested. I much prefer that. But you see all these variations, including McGill. The contract language in McGill, and to some extent the stipulation by Citibank's counsel McGill, is almost imponderable. But that's the record you've got to deal with. I mean, Citibank made a stipulation that's hard to believe.
You know, one of the questions that people don't often raise about the Supreme Court's view here is whether it's just antipathy to class actions, which is quite apparent, or whether some of this grows out of the fact that there's an astonishing low amount of actual trial experience, especially civil trial experience, on the justices of the Supreme Court. Anthony Kennedy practiced with his father in Sacramento and had a real law practice in terms of real clients. Sonia Sotomayor was a trial judge in the Southern District of New York. But if you look at the others, Justice Alito was a U.S. attorney and tried a great many criminal cases, but no real record of civil cases. And you look at the others who were either academics, came up through what is now the bureaucracy of the federal system. We no longer have justices appointed from the whole range of American society. They come up as bureaucrats. From district judges, they have to be part of the Harvard-Yale axis. And the real question is the lack of actual experience of the civil jury and trial process by the members of the Supreme Court affecting their views of this. There is one oral argument. By the way, as you know, the Supreme Court now releases oral arguments of all the cases that they hear, and I think it's probably come beneath a standard of practice to not listen to them because of what you hear in the oral arguments that you don't get from the opinion. But in one oral argument involving a procedural pleading issue, I remember, and it involved discovery connected to a pleading issue, and Justice Breyer asked, do you mean to say that simply by filing a general complaint you can get the ability to force all this discovery on your opponent? I think the absence of, we have a Supreme Court that is divorced from the daily realities of client representation and civil trials. So it's a real question about whether it's just antipathy to class actions or even those who have had some experience. I think Justice Kennedy may be the only person on the Supreme Court, even though I mentioned the experience of others, who actually had a human client which he represented in court. I don't think any of the others have. Yeah. Yes, Bill?
Good example of that lack of experience, if you recall, when Bill Clinton did not want to give a deposition. The issue went to the Supreme Court, and the ruling was 9-0 against him, saying, don't worry about it, it's not a big deal to give a deposition.
Yeah, that's right. That's as clear an example as people give, although I think one of the problems there is that President Clinton chose to have his personal lawyer, Bob Barnett, argue on his behalf instead of getting someone else to argue on behalf of the presidency as an institution. I think that might have affected the way the court viewed it. But it is classically given as an example for the judge to say, what difference does the deposition of a defendant make? No one who had tried the kind of civil cases that people in this room have tried would ever make that statement.
You know, I think Judge Heiberger is exactly right about this. I think that Concepcion is really more explainable by antipathy to class actions. It followed Basil and Randolph and Stolt-Nielsen, and I really think that's what was motivating Justice Scalia, my constitutional law professor, which raises the question, if that's the motivation, is that appropriate? Is that fidelity to the Constitution? Is that them legislating like they say they're not supposed to do in their hearings? And that's why I have a lot of respect for the courts that still maintain that fidelity and don't participate in that legislating from the bench. I mean, literally saying, what happened to punitive damages? Punitive damages don't exist anymore because there was antipathy to punitive damages. And we're pretending as though the Supreme Court doesn't make law, doesn't do policy. Politics have taken over not only the confirmation process, but the decision-making process. You know.
But Cliff, how different is that? And then we'll go on to the labor cases historically.
I don't know how different it is, but if judges stop saying separate but equal, I'm glad they did. I'm glad the judges didn't simply blindly follow Plessy versus Ferguson. At some point, your conscience has to rise up. You put your name on the opinion, you know.
It's not only antipathy to class actions, which is some of it. It's also 10 years ago, no one, not a single lawyer in this room, ever thought you could have a class action in arbitration. It never happened in America. No one ever thought of doing it in America. And it's because the arbitration procedure doesn't work very well for class actions for all sorts of reasons, including consent, because you got to consent to arbitration, including the lack of appellate review. And so part of what's going on here is absolutely, as Bill says, the majority of the Supreme Court, they just don't like class actions. But the other big part of it is we haven't figured out a way to have a class action in an arbitration that works very well and is very fair to the party.
And there is a way that we'll talk about that's an alternative to this technologically. The advances in online dispute resolution of dealing with individual disputes of quite a significant amount actually, theoretically, actually could provide a kind of remedy for individuals here. eBay has led the way, as well as other companies. That's a different subject. That's a different question.
But the lawyers disappear.
What?
And indeed, that was the hypothetical contract, not hypothetical, the actual Third Amended, Fifth Amendment, 13th Amended contract that AT&T had put out there. Because AT&T, as I understand it, probably with Mayor Brown's advice, was fly-specking what to do with their adhesion agreements until on the umpteenth iteration, they got the one they wanted to take up. But more generally, the eBay model has something to be said for it. I mean, we have a lot of self-represented litigants in our courts, and we worry about that because we do provide justice. But having said that, the lawyers here, particularly the plaintiffs' lawyers, can understand if you create a hypothetically good legal system that requires people to do it on their own because there's no economic reason for a lawyer to be involved, it is a theoretical access to justice. It may even be a sufficient access to justice, but clearly when you freeze out the plaintiff's bar's practical opportunity to provide service, it is not the same kind of access to justice.
And I will just add that one of the problems with class arbitration and with using arbitration to impact the rights of those more broadly is that those absent persons are not present, and they also don't have the right for notice and to be heard and to opt out and in the way that they do in a court proceeding. And that's my concern with McGill. And I'm going to go a little further than Rex here and say that is about the rights of absent persons as well, because of the impact on society more broadly and on the public. And that's the issue that we're confronting with PAGA right now in California, which I hope we'll get to talk about, because even though those aren't class actions, they're still cases that and disputes that will have a very broad impact on society as a whole, and arbitration, I don't think, is well suited for that.
I want to agree with my colleagues here. I do not believe there is such a thing as class arbitration. And it's been more than 10 years. I think the California Supreme Court in some Blue Cross case about 30 years ago allowed there to be something called the class arbitration. What we now call class arbitration is really a special master or a reference process. You have an arbitrator, you can go to court to appeal the clause interpretation. You go back to the arbitrator, then you can go back to court. That's not arbitration. There's no definition of arbitration that allows you to go to court twice during the process and appeal the rulings. And I completely agree that class actions are not properly suited for all of the reasons you said for arbitration. The solution is not to allow corporations to ban arbitrations, to ban class actions. Class actions, even though I don't enjoy bringing them, they do serve a purpose in small cases. The plaintiff's bar did not create the class action process. It was created by the courts as the most efficient way to handle small claims. And if they don't belong in arbitration, they should go to court. Public injunctions that can be monitored by a judge. How does an arbitrator monitor an ongoing injunction? So the answer is, let's be smart. What's the purpose? What's the best way to do it? What is public policy? Public policy is not to allow companies to opt out of the law, to unilaterally prohibit class actions, to suppress claims. That's not a public policy. That's where we are. But I think that we absolutely agree. I don't think class actions should ever be in arbitration.
Having agreed on that, let's turn to the employment arbitration issue, because in the Supreme Court, sometime in the October 2017 term, probably in November, December, these cases will be argued. This is the issue about whether the Federal Arbitration Act provision making the arbitration contracts enforceable overrides the provision of the National Labor Relations Act, giving all employees the right to concerted action. That's a right that's in addition to the right to unionize. It's a statutory right to concerted action. The circuits are hopelessly split on this. If I've got it right, the 6th, the 7th, and 9th have held that the NLRA trumps. The 2nd, 3rd, the 2nd, 5th, and 8th have gone the other way and held the FAA trumps. There are 3 cases that were granted cert and consolidated, one from the 9th, one from the 5th, one from the 7th, where the NLRB is a party. The court, as I said, the cert petitions have been filed. That's the issue in a nutshell. You've got 2 statutes. You've got the FAA contract for arbitration for enforceable and irrevocable. You've got the National Labor Relations Act. Employees have the right to concerted action. Does one overrule the other? This may be a case in which whether Merrick Garland or Neil Gorsuch is on the court will make the essential difference because of their different views on the Chevron deference rule. But let's turn to that, to these cases that are being briefed as we speak, that will be argued this term, and will decide an issue that will affect every employee in the United States. Rex, you wrote the cert petition. Will you take the lead? And somehow, why don't you mention in the midst of this also Iskanian and how California had dealt with NLRB and the PAGA issue? I think it's something we should also talk about.
Well, let's start out with the issue. Once Concepcion was decided and the Supreme Court said, okay, state can't have a per se ban on class action waivers, that is class action waivers and arbitrations. Then a lot of employers looked around and said, okay, we're going to have all our employees as a condition of employment agree to A, arbitrate their claims, and B, there will be no class action, collective action, or anything like that during the arbitration. They'll all be individual claims. Understandably, the plaintiffs' bar then looked around and said, well, there's got to be some way we can defeat this. And so they very creatively brought claims under the National Labor Relations Act. As Howard was saying, the National Labor Relations Act provides, in somewhat vague language, a right to bring or I shouldn't say right to bring a right to engage in concerted activity. Obviously, that plainly covers organizing unions, strikes, and things like that. Whether it goes any further than that, the Supreme Court has never said. There are a number of NLRB decisions and some lower court federal decisions that have said that that right to concerted activity not only covers union organizing and things closely related to union organizing, but it also includes any collective legal actions brought by people that affect working conditions. And therefore the argument is that properly interpreted, that NLRB provides a right to bring concerted activity that includes collective legal actions like class actions. And from that premise, the argument then is that trumps the Federal Arbitration Act. So any waiver of the right to bring a collective action by employees is argued by the plaintiffs to be trumped by the National Labor Relations Act. So that's the first issue. And there, as Howard says, there's the Chevron deference issue, which is the NLRB has squarely held, unless it changes its position, which is in flux. But right now, the NLRB is still adhering to the position that the National Labor Relations Act does trump the Federal Arbitration Act, but more importantly, that within the scope of its expertise is the right to determine what the National Labor Relations Act covers. And the NLRB says it covers concerted activity, which means collective legal actions like class actions. So that's the first big question in the case, really, whether or not the National Labor Relations Act creates some kind of right to bring a class action that affects employment conditions. The second big issue in the case is, assuming the answer to that is yes, then the National Labor Relations Act and the Federal Arbitration Act are in clear conflict given Concepcion. So which then controls? The argument that we have made is that there is a line of U.S. Supreme Court cases, unbroken line of U.S. Supreme Court cases, that says that when there's a conflict between a federal statute and the Federal Arbitration Act, the Federal Arbitration Act controls unless Congress expressly says it doesn't control. And the Supreme Court has said that repeatedly in the face of arguments that all sorts of federal statutes, like the securities laws, like the antitrust laws, like the Fair Credit Reporting Act, like the American with Disabilities Act, and so on. When there's been a conflict between those and whether or not you can go to arbitration, the Supreme Court has always said it's up to Congress. Congress has got to say expressly that it doesn't want the Federal Arbitration Act to control. If it doesn't say that, then the Federal Arbitration Act controls.
That's why Chevron deference is so important, because in none of those cases was there an administrative agency to which Congress had delegated authority to exercise its expertise.
Right. Now, the plaintiff's argument, which I suspect Cliff will give more accurately and articulately than I can, or at least I'm prepared to do, his argument is that there is a savings clause, what's called the savings clause in the Federal Arbitration Act, and which says essentially that arbitration agreements are invalid if they're contrary to normal contractual law. So if an arbitration agreement is procured by fraud, it's not enforceable. If it's contrary to some public policy, it's not enforceable. The plaintiff's argument is that controls here because the National Labor Relations Act makes it illegal to have as a condition of employment that an employee waives their right to concerted action. And illegality is widely recognized, I think, in every jurisdiction in America as a defense to a contract claim. Our response to that is to say, well, that's fine when you have a state law, but here what you have are two federal laws in conflict, and the question therefore is not whether the savings clause applies. The question is, what the hell did Congress think it was doing? Did it think the National Labor Relations Act was supposed to trump here? Or did it think the Federal Arbitration Act was supposed to trump? And then we go back to what I said before, which is there's an unbroken line of U.S. Supreme Court cases that says when the conflict exists, Congress has to say expressly it's trumping the Federal Arbitration Act. If it doesn't do that, the Federal Arbitration Act applies.
The broad question, what the hell did Congress think it was doing, is generally applicable, I think.
Yeah.
But Cliff,
Well,
Cliff, the other
just
side.
one little tiny thing to that, which is that at the time the Federal Arbitration Act was adopted, the National Labor Relations Act didn't exist.
And I'll put in one piece of legal history before I give it to Cliff. The other oddity of the Federal Arbitration Act passed at a time when arbitration, as then known, was between business to business, often in admiralty, sometimes in business like textile and other specialized industries where they wanted an arbitrator who'd know sort of the culture and custom of the industry or the trade. But I think because they were getting close to dealing with arbitration in the world of admiralty and water shipping, marine shipping, there's a carve out because there were actually some interested unionized workers who were close enough to the negotiation that there's a very narrow exception in the Federal Arbitration Act for a very narrow class of workers, although it has some relevance, even perhaps to port workers, because I believe it's Section 1 of the Federal Arbitration Act excludes coverage to workers engaged in interstate commerce. Well, if you take a Title VII interstate commerce theory of what's interstate commerce, isn't that everything? Well, actually not. Indeed, if you take the what Does the Federal Arbitration Act apply theory of commerce? Is it everything? Well, the answer to that is yes. But when it comes to the exception, the answer is no. You've basically got to have dirt under your fingernails running a locomotive across the border in a tugboat or a steamship going to Hawaii or China, or otherwise driving a truck to Seattle or Tijuana. So it's a very narrow exception of workers that doesn't apply to the general run of workers. But that small group of workers thought to get Congress to carve them out. Remember, Coolidge signed this, not FDR.
Well, I think the Railway Labor Act might have been passed in 1925, the same year.
Could well be, but in any case, and of course, there was voluntary arbitration in certain kinds of industries that had early unions, but this form of forced arbitration was being avoided for that workforce.
Let me revise the history here. This issue was not created as a response to Concepcion. And I know that because I was the one who filed the charge. The story is actually pretty interesting. We argued Gentry. We got involved in arguing Gentry, thank God for Justice Moreno. I wanted to insert into our brief this NLRA preemption theory. The plaintiff's attorney was begging me, don't do it because we don't want to get preempted, we don't want to deal with those issues. So we only had it as a footnote in our brief. But when I stood up in the oral argument, I just couldn't help myself, and I said, it also violates Section 923 of the Labor Code and the National Labor Relations Act. And Justice Moreno, from the end of the bench, said, do you have any authority for that? And I literally said, not yet. And he was good enough to write the decision prohibiting class bans without mentioning my theory. So 2 months after Gentry came out, I filed the first charge with the NLRB. Challenging the class prohibition. And just for context, because context matters, I had a case that was referred to me actually by someone who worked at the cosmetics counter at Neiman Marcus who knew Kamala Harris. She sent to the former city attorney, sent it to me. Neiman Marcus came and said on a Tuesday, if you show up at work next week, you will agree everything goes to arbitration, that every arbitrator has to be a resident of Texas and a member of the Texas Bar. The statute of limitations is 1 year no matter how long you would have under law. No class actions, no joinder, no consolidation of cases. And keep in mind, this issue deals not only with class actions, but with joinder and consolidations and representative actions. So we filed the charge. The NLRB did what they do. They spent 2 years. We took 2 trips back to Washington to meet with the general counsel, who was a Republican at the time, who kept saying, why did you bring this here? Like, oh my God, why don't you just go to court and challenge it as unconscionable? And we said, we can't, because it's preempted, it's the federal labor law. 2 weeks before he left the general counsel position to go work at Proskauer, he decided he didn't want to bring a charge, and he settled the case. And we then waited for there to be a new general counsel. We refiled, and we worked the case up when D.R. Horton had been decided in the lower courts in an ALJ hearing. And we worked with the NLRB. We got the Department of Labor, the EEOC filed the amicus briefs, and the department and it was, there's literally been 60 years of precedent, and it's not just ALJs and some board decisions. The United States Supreme Court in the Eastex case said that filing a class action in court is protected concerted activity. And this isn't just about the FAA. The Norris-LaGuardia Act, which was passed before the National Labor Relations Act, literally says it is the public policy of this nation. Literally it says it is the public policy of this nation in interpreting employment laws to recognize that we've allowed corporations to accumulate wealth and exist in the corporate form, and that individual workers don't have the ability to freely negotiate terms of labor. Therefore, you have the right to organize, act in concert for mutual aid and protection. It then goes on and literally has a section, a caption in the statute called Yellow Dog Contracts. And it says that any contract inconsistent with this policy shall not be enforceable in any court in this country. The National Labor Relations Act was passed a few years after that and says pretty much the same thing. And for the next 60 years, there has been, if you want to talk about consistent chain of authority, saying that you can't prohibit this kind of concerted action. It doesn't only mean union representation, it applies in the non-unionized workforce. The reason that they're right is first, the Norris-LaGuardia Act says this is the public policy. The FAA public policy is made up. It doesn't exist. The NLRA is the most profound public policy relating to labor relations in this country. It has served this nation well. We don't have people busting heads and the violence we had. It has served us well. No one can seriously argue that the public policy behind the NLRA isn't more important than some made-up public policy to increase the arbitration caseload. But more importantly, the FAA, it's not a matter of the NLRA trumping the FAA. The FAA trumps itself. The FAA says that you don't compel arbitration if it's a contract that would otherwise be illegal. Most of the Supreme Court cases where they're slapping down the California courts and slapping down state courts deal with preemption. There is no such thing as preemption of one federal statute over another. The role of the courts is to try to reconcile them. The NLRA, the NLRB has not said you can't, that you can't require arbitration. They just said you can't prohibit concerted activity everywhere. You can't prohibit it in court if you also prohibit it in arbitration. It's not an anti-arbitration case. It is simply saying you cannot prohibit what is now the most effective form of concerted action everywhere. So there is no preemption. The Savings Clause says it. The FAA says it. But the key to this is something that I was playing with Rex about before. The question here, which distinguishes it from all of the other cases that you're referring to, is whether or not the right to concerted action is a substantive right. I'm not talking about Rule 23. The Supreme Court says that's a procedural right. And in whether it be, all of the Supreme Court cases are saying it's just a procedural device. The very first line of the D.R. Horton decision, which predated these three cases, says that the NLRA creates a substantive right. And that's exactly what the Sixth Circuit said. And if they are right, and in fact, the Sixth Circuit decision that just came out, it was really interesting because it said there is only one substantive right in the NLRA, the right to act in concert. And everything else in that legislation is there to effectuate that one substantive right. If the right to act in concert is a substantive right, then there is an unbroken chain of U.S. Supreme Court cases that say you cannot use arbitration to undermine substantive rights.
But how is the filing of a class action, which didn't even exist at the time of the NLRA in the modern sense? This is a new, but class actions in the modern sense are a relatively new creation, and they didn't exist at the time. So
social media is a new creation. The NLRA doesn't allow employers to say you can use this form of concerted action but not that form. The employer doesn't get to choose what is effective and what is not effective. Concerted action means joining together. And the U.S. Supreme Court itself has said that filing a joint action, and think of this, forget class actions, think about collective actions. The employment relationship is different. I may be dreaming here, but if you go back and read Concepcion, every single reference to that arbitration agreement called it a consumer arbitration agreement. They went ahead and they took a backhanded slap at the California Supreme Court and said, after they decided to discover bank, they decided these other cases, allowing, prohibiting class action bans. Every single case they mentioned was a consumer case. For some reason, the U.S. Supreme Court did not mention Gentry, which is really odd, because that was the most significant, profound decision, and they didn't mention it, because the employment relationship is different. It's different for a bunch of reasons, but there are at least four federal statutes that say on the face of the statute, the Fair Labor Standards Act, the Equal Pay Act, the Family Medical Leave Act, and the ADEA all say one or more employees may file a claim on their behalf and on behalf of others similarly situated. That's in the statute. That is Congress saying that the employment relationship is different, that the fear of retaliation is real, that it is not practical to sue your employer in your own name and keep your job. When I went back to the NLRB, I don't use, I use passion and I don't use demonstrative evidence, but I took a target and I held it up to my chest. Because what this is about is the knowledge that if you force workers to file in their own name, they are afraid of retaliation, it is real, and they will not file. That's why employment is different. I don't know what's going to happen. I've lost faith in the institution of the Supreme Court, so I'm not going to predict. But I know it's right. And this would be a complete disaster. I'm not sure that with Justice Scalia gone, that there is still that zeal to literally overturn. Because think about it. What if your arbitration clause says you can't be represented by the union in a union grievance procedure? You have to go to arbitration at the National Arbitration Forum. Can you completely undermine all of the aspects of the NLRA by using an arbitration agreement? Is there anything that we can't throw into an arbitration agreement, that won't get enforced? I don't know. But is this serving the best interest of the country or?
Judge Heiberger, we're going to pretend for a moment it's Judge Heiberger's court, so he gets to talk. Go ahead. Okay.
That's fine. Cliff, first, I'd written this down here actually before you said it because I was going to bring this up. The Norris-LaGuardia Act, to me, is this just sleeper cell of an incredibly powerful weapon for the plaintiff's bar. I never see it argued. I put it in a presentation to teach judges at Seizure. I had a picture of it, but I don't hear it argued.
That's how we argued it to the NLRB. It's in D.R. Horton.
Well, your brethren and sisters aren't arguing it, which is surprising because it's right dead on. Now, I'll keep going if I may, Howard.
Keep going.
You can keep going as long as you agree with Cliff, at which point.
No, that's okay. I'll leave it to Rex to explain the Eastex case to the Supreme Court because I did do classic management union labor law as a young lawyer enough to know cases like Eastex. And it's a little bit like the Bible, wherever two or more gather together. Oh, it's wherever two or more do something, pushing back against the boss, that's concerted activity. One person yammering, not so easy. Two people together yammering to the boss, that looks like concerted activity. Now, you can, as Van indicated, have a question about whether the courtroom device of a class action is two or more gathered together in the form of it or not, but it's certainly, I think, a fair fight. The thing, if I were Cliff, and he's sort of anticipated it by his comments about the current jurisprudence, is the Supreme Court in Italian colors had to deal with the Sherman Act versus the Federal Arbitration Act and found no problem with elevating the Arbitration Act over the Sherman Act. The federal U.S. Supreme Court in CompuCredit versus Greenwood more recently had to deal with a case that talked about your remedy was to bring an action, and they decided action didn't mean action, it could be action or arbitration, and said, no, the fact that Congress in a recent statute said that your remedy was to bring an action didn't really mean that you had a right to go to a court, state or federal, in lieu of arbitration. At least the Supreme Court that we'd seen until recently seems always to put arbitration over the other federal statutes whenever they have a trade-off. Is there anything that gives you hope, Cliff, or is it just Scalia's passing?
I think the implications are so profound that they would have to overturn Chevron deference because the whole, whether it's, big deference,
Well, I thought they were ready to overturn it for other reasons, though. I thought
they may,
particularly
but
with Gorsuch, he didn't like Chevron deference.
But is it a substantive right? They'd have to overturn all of their cases about you can't prohibit outright, as opposed to Italian colors, which was an indirect that's too expensive. This is a direct prohibition, and for the same reason Rex thinks McGill is right, I think it's the same logic here. It's a substantive right. It is and I just think the implications of it take down the entire NLRA. Now, that may be part of the Chamber of Commerce agenda, and it may happen. Listen, we're living in bizarre times, so I'm not going to say it's not going to happen. And it may be that, Steve Bannon is right, that we need complete anarchy and the system to collapse to rebuild it. But I hope that's not the case. I'm trusting that someone there, whether it be Justice Kennedy or perhaps the change in the environment, since in the past couple of years, whether it be the New York Times or the major media, there's been a change in the national debate about prohibiting class actions, about secret arbitrations, about Roger Ailes being able to send sex harassment cases to arbitrations. And I think that there has been a change in the consciousness of the country. And I think that at some point it will filter in, and if it doesn't, then we might as well just cash it in. Because if literally a company
But
can
before
write
we
itself...
cash it in, I don't want you to keep going and cash it in. Let's let Judge Heiberger comment again.
Two more comments. I've certainly heard it from people who know the Supreme Court well, that anytime there's a new justice, the reworking of that family of 9 people does create a change. Maybe there'll be another change in a year or so, but they've had a change. Scalia's gone, Gorsuch is there, and in that sense, apparently it is just the nature of the group dynamic that change will happen. Having said that, I'd make the following more general comments. I've known Rich Chernick since I was 23 when I was a young attorney interviewing. I know that he and other arbitrators go about their business as conscientiously as I do as a judge. Having said that, there is some truth in the 1920s, judges were hostile to arbitration, and in the 20-aughts and in the 20-teens, judges are hostile to arbitration. I was on an ABA committee involving business court judges from around the country. This is shortly after Concepcion came out. Went to a meeting in Vegas or somewhere where we're gathering the judges from around the country together, and I sort of said to the other judges in the room from multiple states, are you eager to enforce arbitration agreements? And the collective, no, because there is a collective hostility to arbitration. I frankly think there's a lot to be said in favor of the public courts, the transparent process, no disrespect for James and my retired colleagues in arbitration, but in a process that people can look into that's somewhat separate from the question of where or how class actions are arbitrated, but a public justice system you can look into. Having said it, having looked at the U.S. Supreme Court cases over 20 plus years, probably even before Scalia got on the court, of all the courts in the country that are always pro-arbitration, the one court that has been predictably pro-arbitration has been the U.S. Supreme Court. The one case that arguably stands out as sort of an exception is Volt Information versus the trustees of Leland Stanford Junior University, where you've got 2 co-equal powers who negotiate an odd agreement to sort of arbitrate but sort of apply state law. And the U.S. Supreme Court at the end of the day says, if that's a deal you want to make, we'll enforce it. And they actually are sort of enforcing arbitration, but they're enforcing it with a one-off set of rules. Otherwise, the U.S. Supreme Court is the one court that through thick and thin, through changes of staffing, has always been pro-arbitration. Now, maybe it's because with a discretionary docket, they have a very different attitude about when they're closing their courthouse to others. I think that with the taxpayers' dollars that still let us run a court system, we provide a very important public service. And I would, frankly, given a choice, prefer to provide that in my courtroom. Do I enforce arbitration? Yes. Do I write lectures and give speeches that indicate the judges have to enforce arbitration? Yes. Why? Supremacy clause. Latham doesn't have flag here, but I've taken an oath to support the Constitution of the United States that's got a supremacy clause. Once you got a supremacy clause and you got 5-4 decisions that tell you what you got to do, at some point you do it because you got to do it, not because you think it's good policy.
The question from Jim Adler. Jim?
I don't want this to be my only comment, but I think, Bill, the answer to your question about why plaintiffs don't raise this, in the first place, law schools across the country, even good law schools, barely teach labor law, if at all. And the current crop of younger plaintiff lawyers came out of plaintiff lawyers. They don't have labor law background.
They're former med mal lawyers, best as I can tell.
They have no idea that the national labor law exists. They have no idea the North Security Act is. They have no idea what the power of these arguments are. Cliff does, but Cliff's got a lot of gray hair. The younger lawyers just don't know this law, and the Supreme Court, it's hard to, if you've got an hour or 30 minutes, you can't educate them in the whole history of the labor law. So they really don't know it either. None of them have been almost none of them have been practicing lawyers. Very few of them have any labor law background. They don't understand this whole background, and you can't teach it in 30 minutes.
This is Jim Adler channeling Cicero, o tempora, o mores.
And when they do learn it, they mess it up. When we were working this D.R. Horton issue at the NLRB for about 6 or 7 years, and we just kept quiet because we didn't want other people to mess it up. And as soon as Horton comes out, people who had class actions thrown out because of Concepcion, they add it as a footnote or the last paragraph of their brief without any context. And that's why we started seeing these district courts just slapping their hand at it, because it was raised for the first time on appeal in 2 paragraphs. And we had people just take this beautiful precedent and just like throw it away as a throwaway argument.
The Supreme Court certainly gave it no credence.
Yeah, I bet you Justice Liu is pretty embarrassed about that decision at this point, now that the Ninth Circuit has gone the other way, and he agreed with the Fifth Circuit analysis, which was really silly.
Well, I want to add one more complexity to this because there's something we left out, and I'd like Theani to talk about it. There is a California Supreme Court case which deals with some of these issues aside from the NLRB issue. In fact, the opinion refused to apply the NLRB opinion in terms of the final decision. It's the Iskanian case, which leaves open an entirely different issue about Private Attorney General's Act. Theani, could you give us a quick summary of Iskanian and what's involved there?
Sure. Well, on the, as you mentioned, on the D.R. Horton issue, the California Supreme Court joined the Fifth Circuit and the Second Circuit in holding that the NLRA did not conflict with the FAA, and that later the Ninth Circuit disagreed in the Morris case. So you had a situation where you have the state's highest court and the federal court taking different positions on this issue. But the other part of Iskanian that is that's important is the part about the PAGA, which is the Private Attorney General Act, which really wasn't used or invoked much until after class waivers became enforceable in California, and then plaintiffs' lawyers were looking for a new mechanism to bring claims on behalf of more than one individual, and they turned to the Private Attorney General Act, or the PAGA, which is really, if you look at the law, it's really become a sort of Frankenstein statute, because the courts have, the California courts have held that although these are representative actions and the individual who brings the case may bring it on behalf of absent employees and stands in the shoes of the state in a sort of quasi-qui tam way, the class action procedures and requirements and restrictions don't apply. So it's not a class action, it's something else, but I think it's difficult to, for any of us to say really what it is, because at the same time, it's impacting the rights of if you bring a PAGA case, of every employee across the state. And who has the right to stand in the shoes of the state where multiple plaintiffs bring overlapping PAGA actions, and each one is trying to say, I'm the state. And so what we've seen is a huge increase in PAGA actions, and the California Supreme Court held in Iskanian that PAGA waivers were unenforceable and against California's public policy, because there is a public benefit of the PAGA and the right to bring that can't be waived. So right now, if you have a PAGA waiver in your arbitration agreement, you better hope that it's severable, or else the agreement won't be enforceable. And the PAGA action will have to proceed in court, where the class action may be waived, and that waiver is enforceable. The PAGA action has to go forward in court. So now we've seen a huge increase in the number of PAGA cases in California, and so the Ninth Circuit addressed this issue in the S.Ct. case, and S.Ct. there was a cert petition filed. The Ninth Circuit agreed with the California Supreme Court in Iskanian that PAGA waivers were unenforceable. And there was a cert petition filed, but then that case settled and went away. And it's really unfortunate because it's such an important issue. There's now another cert petition pending in the Supreme Court on the same Iskanian SACOB issue, and it's also out of the Ninth Circuit, and it's the case of Bloomingdale's versus Vitolo, and it's going to be conferenced next week, actually. So we may see very soon if the Supreme Court is interested in the issue of whether the FAA preempts PAGA waivers, and the argument for that preemption would be really the same as in Concepcion, that a PAGA action where the individual is proceeding on behalf of the state and thousands, sometimes tens of thousands of absent individuals, that is incompatible with the traditional character of bilateral arbitration and therefore impermissible and preempted.
We wanted to leave a few minutes for a general discussion of policy. I think one of the things that's come out of this discussion is the focus on how the arbitration, the class action waiver, is really being considered in the context of concerns about class actions, and that it's concerns about class actions that may be driving a large amount of the jurisprudence, and that the FAA is simply the vehicle for the court to develop its concerns about class actions and to implement them. Judge Heiberger, where do you see this going in terms of class actions and arbitration? Do you agree that a lot of this is driven by concerns about class actions? Do you think the concerns are justified? And where do you think this goes in arbitration as a vehicle for dealing with the class action issues?
The edicts we've gotten from the U.S. Supreme Court historically, up to now, have been concerned or driven, I think, by a concern about class actions. Will the reconstituted Supreme Court have the same level of passion about the topic? Not clear. Justice Scalia is gone. Justice Gorsuch is sort of his clone in a way, but he is a different person. With the Congress, forget about the incumbent in the presidency, with Congress being controlled in either house by Republican majority and likely controlled in both houses by Republican majority for at least a couple of two-year sessions. The odds of Senator Franken, a Democrat from Minnesota, getting his Arbitration Act reform passed are nil. And the Consumer Financial Protection Board, Senator Warren's pet, the odds it's going to effectively pass regulations invoking federal law to try to limit consumer credit arbitration are close to nil. They may put something out there, but given that they're already on the ropes in terms of their legal authority to exist, it's not going to happen. In a perfect world, the Federal Arbitration Act would greatly stand some amendment. There are times when arbitration has a lot to be said for it, even times when Cliff might not agree that it's good, but probably in the grand scheme of things is acceptable. But there are other metes and bounds that ought to be reset so that access to the public courts are preserved for important things, probably including injunctions. I mean, theoretically, as I understand it, you can go ask an arbitrator for an injunction. If the award is rendered, in theory, you go back to state or federal court and try to get that award enforced. I haven't ever seen one in my life, but theoretically, you could go down that way, to my understanding. How much a judge would really want to enforce an arbitrator injunction, you got to wonder. Only because you want to be sort of comfortable. You know, the Monclar standard is not the standard I'd want to apply before I enforce an injunction that applies particularly to third parties. So this is what we have at the moment. It is a very imperfect world. I don't think any other reform of class actions is going to happen, though. So until a different majority of the U.S. Supreme Court falls in love with class actions with the same enthusiasm that, by way of example, our state Supreme Court loves class actions. They're almost blinded with love of class actions, but they definitely love class actions. The U.S. Supreme Court has almost the diametrically opposite view in terms of a majority. So until they get rid of those sentiments, I don't think much is going to pass. I would urge you, Howard, as a moderator, to open it up to our audience, because I think actually with the sophistication we have here, I certainly don't mean to cut off my fellow panelists, but a more vigorous interaction with the audience, I think, will contribute to knowledge.
I think that's a great, yes.
At the risk of having another 15 minutes or 30 minutes up for each of you, what do you think is the...
That's certainly a judgment on
Sorry
the
for making
panel.
you sit through this.
What do you think is the result when the employer has an opt-out clause, which in theory makes the whole thing voluntary and even wipes out Armanduras?
The one I loved was where an employer gave somebody a day's comp pay if you didn't cancel the agreement. So they put everybody in the room, they made them all sign an arbitration agreement, but they said, by the way, you can go to HR for the next month, cancel this, except that day of comp time we gave you, you won't have it.
Let me, Justice Moreno's here because this is exactly the issue we addressed in Gentry. It's one thing to have an opt-out clause for your cell phone. It's another thing to tell an applicant for employment that you must, as part of your application, tell the employer, I want to preserve the right to sue you. It is not, it is coercive. It is what you would call polling in the union. How do you feel about unions? You want to join a union. Employer, an employee walks in with certain rights. The employer should not have the ability to say, you must call this 800 number in Richmond, Virginia, get a form, send it back to me in 30 days, or you lose your rights. You can't take your rights and you have to put a target on your chest. It is coercive. It's the same thing. How do you feel about the rebates you get that you never cash in? They understand that it is a fake step trying to buy you some lesser procedural unconscionability. But as Justice Moreno correctly pointed out, it is still somewhat coercive.
I disagree. How is it coercive? You're not giving up your right to assert your rights. You can just bring them in a different forum. And by definition, it's not coercive if you have the right to opt out, and it's very clear, and there is no retaliation for your exercise for it. I mean, of course, if you had some unique facts, I could see what you're saying, but in the normal case, I can't see how that's coercive. And I also don't know any employer who wants to have thousands of individual arbitrations. And we've seen with AT&T, for example, that there have been many arbitrations brought. So, be wary what you wish for.
Yeah, well, no, be wary what you wish for, because every time, right now, what you've got a voracious, and I say this as not being one of them, I hope, a voracious plaintiff's class action bar. And if you ban class actions, they're going to advertise, they're going to solicit, they're going to sign up 400 cases, and you're going to be paying 400 sets of arbitration fees. But right after D.R. Horton came out, Littler Mendelsohn says, here's your way around it, give a 30-day opt-out. The case that I actually filed at the NLRB that led to D.R. Horton had a 30-day opt-out. And the ALJ correctly and the NLRB correctly have said, you can't do that.
Yeah, unfortunately, the Ninth Circuit said you can.
Well, the Ninth Circuit didn't defer to the NLRB as they were supposed to. They were nor did they defer to Justice Moreno. The Ninth Circuit had no business determining what is unconscionable under California law, and they did. But that John Muhammadi throwaway line is not long for this world.
Not a throwaway line.
It's a throwaway.
Just the whole.
No. It was a footnote. It was a footnote.
Well, it's clear, by the way, based on Cliff's discussion, so much of this is a reaction to the decline of unionization in private industry. I mean, there was a whole other established way of dealing with this that doesn't exist for the most part now in private industry. And this is a reaction by individuals who are trying to establish other ways to enforce employee rights in what is basically a non-unionized world. We're also moving to a world of independent contractors. The entire picture of employment is changing dramatically. And a large part of this is not just the reaction to class actions, but Fiani or Rex, don't you think also to the decline of unionization? This used to be handled through collective bargaining agreements always. And now in the private sector, there are so few collective bargaining agreements.
Well, I think Howard, there's no doubt that you're right about that, because class actions have become kind of the way to bring employees together to do something. You used to do that with unions.
Concerted activity.
Concerted activity.
Right.
Let's hear about that. Are there more? Let's see if someone from the audience, Judge Imburgia, right? Is anyone else? Yes.
I just have one comment, and that is, we're talking a lot about all these labor laws. Every collective bargaining agreement that I've seen, and I've been practicing a long time, has an arbitration provision. The union gets to decide whether or not a case gets arbitrated or not the employee. There are no strike clauses in the agreements, which means that people are giving up their rights to protect a concerted activity. So this is a big part of labor law. It's not like everybody's out there for years and years and years doing whatever they want. They gave up their rights, and the union gave it up for them. So,
And the union's a repeat player. I think in all candor, the argument about buying power in the world of alternative dispute resolution has a certain cogency. A union, and particularly a union law firm, has as much, if not more power than the employer buying that kind of, Joe Gentile, I remember him, rest in peace, those kind of arbitrators, which is very different than the lawyered up kind of arbitration you see for private commercial disputes and even the stuff that gets referred out under these employment agreements where indeed you have to have some discovery. The kind of arbitrations I did as a young lawyer at Gibson Dunn for Southern California Edison and the gas company, no discovery, total trial by ambush, what fun. But it wouldn't satisfy Armendariz. But the point is the union had co-equal buying power with the neutrals, and just like the arbitration as it existed when the FAA was passed in the early 1920s, it was amongst voluntary parties. Cliff made
They're
the
not
point.
arbitrating statutory claims that require discovery in the application and the development of law. If you want to arbitrate just cause, I'll arbitrate just cause with you all day. This is about prohibition, and in the labor context, a union can bring a claim, a grievance on behalf of all of the workers. The workers don't have to put targets on their chest, go out and pay a lawyer, and risk being retaliated against. It's a completely different animal. Howard, if there's any chance to use a few minutes to take advantage of a room full of people who are not only experts but who all love the concept of ADR, I would just love to make a plea to everybody that just my personal bias. I think I have an ethical duty to resolve cases at the earliest possible time in the employment field, and in fact, without filing if I can, and I actually do. I love ADR. I don't think jury trials serve most clients. I am very concerned, and I hope that at some point we step back from what the Supreme Court said or is likely to do and take a look at what is happening to the public perception of ADR. All of the good forms of ADR, all of the voluntary forms of ADR, including voluntary arbitration. Your message is not getting out. You can't have every major newspaper in the country focusing on the abuses, on the overreaching, on the confidentiality. It is. You can spend how many millions of dollars on promotion and marketing. It's not working. Half the country at least thinks of arbitration as an abuse and an overreaching, and it is. That if we are going to have ADR in all of its glory, in all of its permutations accepted, it has to be fair not only in fact but in perception. And arbitrators, especially at JAMS and AAA, are good people who believe in their own integrity. And this is not about JAMS and AAA. Think about the National Arbitration Forum. Think about what Circuit City did when AAA enforced its minimum standards. They go find someone who won't do it. That this is a cancer in this system that we would all benefit if 100% of your customers and clients could agree on a menu option of ADR alternatives. What a different world it would be. How can it be that the major providers disregard the heartfelt feelings of not only the plaintiffs bar, half your clients, but hundreds of civil rights and consumer organizations, government entities? How can it be? We have to be honest with ourselves about the impact of a business, justice for business. It places burdens on those of you in the business world, but we are destroying the process of arbitration. Armendariz, when I remember another question that Justice Moreno asked me. This is so funny that you're sitting here. Well, you know, when we showed up in Little, you said, look, if we're going to impose the costs of arbitration, should we do it up front or should we wait to see what happens and do it at the end of the case? And my answer was, don't make the employer pay.
Employee.
Employer. I said, make it voluntary. Everything that we have done to mitigate the effects of mandatory arbitration, adding depositions and summary judgment, we don't have arbitration anymore. We have a non-jury trial. It is no longer a simplified process, and it's all coming about. Making the employer pay violates the very first rule of the due process protocol, that the parties should have an equal stake. You have to realize that I don't think that the neutrals pay enough attention to the perception. They have so much confidence in their own neutrality and their own sense of fairness that they're not paying enough attention to their obligations to be perceived as fair. That no matter how good you are, if someone doesn't trust the process going in, they're not going to trust the result. And I think that we can all work together to expand the use of ADR privately through the courts if we went back to the concept of consent. Let the Supreme Court do what they want. But those of you who are in the business, I don't think it's good enough to say, I'm fair. So it's okay to let Circuit City or Neiman Marcus or 24-Hour Fitness write that kind of clause. It's undermining the quality of your product. And I think that we all in the justice system really should take a step back and work together to create and encourage the use of every voluntary form of ADR.
Thank you, Cliff. We've got to one more question. Go ahead.
I'm just going to make a quick comment, and that is, I'm a retired judge. I am an arbitrator. I work with Judicate West. I'm glad that you didn't include us in the group that you're referring to, Carl.
You will.
But in all seriousness, I feel accused in an area where, as a judge, I felt that arbitration was not the preferred way, that at least access to the court should be there. As an arbitrator, I haven't changed my mind. I don't really have the ability to send them back because I don't have that authority. So when I try commercial, all kinds of real estate matters, all these things that come to us for arbitration, the only thing I can hope for is that the parties, hopefully on both sides, can feel at least that they've gotten a decent shake. Remember that one of the undercurrents that pushed us into this, besides all the things you made, not to argue, all the things you said, is that there isn't an availability of courts. The public has chosen not to fund enough courtrooms to give a civil arena to people that want to litigate their day in, day out contractual business, real estate matters. It's filled with other matters that take priority, from criminal to family law and so on. And you know, courts are bumping against 5-year rules, 7-year rules, and waive rules for another 3 years. And that's also an effective banning of effective justice. And the arbitration arena has filled an important gap in that. And would I love to see 20 more civil courtrooms in Orange County tomorrow to handle the matter, so that there would be that public arena, and so that things that really ought to be in the public forum ought to be litigated there and not have to be hidden in little secret proceedings? Yes, but many of the people come away seriously saying, at least we got a chance to be heard, and heard rather quickly. It may not be cheap, and it may be there's too much discovery, and all your comments have some merit, but I think you got to look at the whole reason we got here.
It's a very important comment, and Judy is standing up, and we promised you 2 hours, and you've earned your CLE. So I'm going to ask everyone very quickly 2 questions. I want each of you to predict how you think the Ernst & Young combined cases are going to be ruled on by the Supreme Court, and whether you think the Supreme Court will take and rule on the McGill case. Quick judgments. Rex?
He's obligated to say his client's going to win.
Yep.
He's also prepared to bet that we're going to win.
Will we have takers? Can we establish a rule?
Sure. McGill, I don't think they'll take.
Judge Ivory?
Decline to comment on Ernst & Young. I don't think they'll take McGill.
Okay. Cliff?
I've lost faith in the institution of the Supreme Court.
Does that mean no
They'll
bet?
rule, I predict against the NLRB's position and that they probably won't take McGill.
With those practical predictions in the midst of a larger and very interesting discussion, thanks to the panel and thank you all for being here.
If I may, just one comment. Enjoyed, I hope this lived up, at least for me, it lived up to my prediction that, or the hope that it would be as interesting or even more than the discussion that I saw in the emails. I do want to mention one thing, and that is I forgot in my thank yous to thank Court Call, which is also going to sponsor tonight. The other thing is this last comment brought this whole thing around full circle to me, because when Bob Weil first started doing private judging, he and I had an argument. And I still, it's one of those, I can close my eyes and remember where we were standing. It was at an American Judicature Society meeting in New York. And we had an argument about alternative dispute resolution. And my argument, and this is something consistent, I think, with what Cliff said and sort of in the theme of what you were saying, is that one of the problems of ADR is that it took out of the public court system the very lawyers and parties who had the resources and the incentive to improve the public court system. And I think that's one of the reasons that we're here where we are now with the issues that confront us in the arbitration world. So I just thought I'd mention that because I thought it was kind of cool that we started with Judge Weil and we're ending with Judge Weil. I hope we will see you again next year. Thank you. And please join me once again in thanking Howard and I think there's still some snacks.
There's food.
There's still food.
A pleasure. We'll get to
The
see you.
reward. Rich, thank you.
My pleasure, Howard.
Good.
As always.
I think.
Thank you. That was wonderful.